So basically, they're going to go back to the place where they think they're going to be able to process a certain number of visas. So what they're looking at is they're looking at the number of people who have filed applications, and they're looking at statistics from the past about how many people have filed during certain timeframes. And they're deciding that they think there's going to be green cards available for everybody with dates before that time listed in the visa bulletin. And so they're going to determine that date based on that data. It's not always a perfect science. They're not perfect at it, but they're going, that just means that everyone can file before that time because they think there's going to be green cards available for that certain number of people. And so, for example, that's why we think, and that's why they put in the visa bulletin for August, that come August, they're thinking the dates are going to shift back to February 2022. And I actually think that's really likely. I actually don't know if we're going to see much progress, but we might, that's one reason why the dates for filing date is instructive. It says in the dates for filing date that they're allowing people to start preparing their applications from June 2022 through the consular-based processes. So that's kind of promising because it means we're probably going to see that date in October jettison back to sometime in early to mid 2022. And my guess is it's probably going to be February again. That's a guess. No lawyer, no person, nobody knows. Like if you ask any of us, we don't actually know for sure what that date's going to be. I don't even think they know what the date's going to be until they start seeing what's coming in for this month.
Absolutely, that makes sense. But I think the only way we can speculate, another way to speculate is that have there been historical instances when EB1A category, especially for India, has it expressed retrogression and come back actually?
Yeah, 2016, 17, and 18, that happened in each of those calendar years. Probably a better example is this happens for EB2 and EB3 almost every year. So if you have an EB2 or EB3 priority date, you're probably really familiar with the shift in dates at this time. And given, I will say, and I got called out on this in a LinkedIn post I made, but 10 years is severe. Like people aren't used to seeing 10-year retrogression, and that is a big jump, right? That's big, so that's scary. But like all it means is there's just that many people in the queue right now. So I think that we'll see some good progress in October, and maybe enough people got scared that they moved to Canada and India that we might see even more progress because less people are applying, which is a terrible thing, but it might be a good thing for people that stick it out. So that's a long way of saying like no one knows what's going to happen for sure.
Okay, understood. Now, I mean, from a preparation perspective, because most of the people in this room right now are on their EB1A journey actually to embark on their next steps or how to do it. So what's the message for them actually? What is the takeaway that this kind of a situation does? Do you see this just as a routine and wait till October not to lose hope, or things are really very bad? No, like wait for, like it has EB1A has become another EB2.
Yeah.
So
isn't it scary? I feel like a lot of lawyers scared people. Like a lot of the posts were kind of scary. I think there was a lot of fear initially when this happened. My thought is like, why? I don't know why anybody would change what their plan was before, because we're kind of seeing this 2022 date. I think within a year or so, we'll probably see 2023. I don't know if that backlog is going to go away for a while, because so many people, so many Indian nationals are trying for EB1 now. I personally, I haven't seen this many people trying for EB1 in my whole career. And in my peers' careers, I haven't seen this many people seeking EB1 as a benefit. I don't know if the backlog is going to totally clear out. I don't know if we'll see it go current anytime soon, but like having it more than a year backlogged, I don't think we'll see much more than that. Like maybe 2 years. I just don't think personally it's going to get much farther behind than that. So the takeaway from that all should be keep moving forward with your EB1. If your plan is to be in the US long term, this is still going to be your best option unless you marry an American. which I can't legally advise you to do that. And I know most Indians don't do that anyways, because your parents are heavily involved in that process. So really EB1 is going to probably end up being your best option for a green card if you want one in the next 3 to 5 years and you don't have a priority date in EB2 or EB3 before 2015, 2014. Maybe even earlier, maybe even 2013.
Okay, and you are saying that the reason for this retrogression has been that too many applicants or people. I think the visa bulletin speaks about it.
You know, the biggest problem, Ranjeet, is Indians are too smart. Like, I don't know why everyone born in India knows so much, but yeah, India, EB1 from Nepal, that's great if you were born in Nepal. You should just file an EB2 though, an EB2 national interest waiver. Whoever's question just popped up in the chat.
Yeah, absolutely. So, so what steps are you taking? So you are suggesting that continue your journey, not to get deterred by these.
Yeah, don't get deterred. Keep going.
Okay. Now, just from an academic perspective, could you explain the process of 485 and the consular processing and when one is qualified to do that actually?
So like the I-485 application?
Yes. And EAD also actually. Let's put it EAD and 485.
And it's an EAD based on your green card application?
Yes, I think so. Because your I-140 is approved. So for example, if somebody applies today, gets a petition approved by premium processing in next 15 days.
For EB1 and they don't have a priority date.
Absolutely. So priority date will be today only actually, if one gets a petition today approved.
Okay.
So what is the likelihood, let's put it this way, of the person getting EAD?
Think of it this way. Think of your I-140 approval, your EB1 I-140 approval as a job offer from the United States government to receive full-time employment permanently in the US. So all it is, this is how I think of it, and it makes the most sense to me. Hopefully it makes sense to everyone else as well. I like to think of it as an offer of full-time employment. So when you get your priority date from the United States, they're offering you a full-time position in the United States. They're just not allowing you to accept that offer of employment until your priority date becomes current in the final action dates, or if they say you can use dates for filing. Once that date becomes current, you're eligible to file your green card application. And I consider green card applications as your acceptance of that offer. You're saying, yes, I want to be in the US permanently. I'm going to file this green card application and accept the I-140 offer to be in the United States. And once you file that I-485, you also can concurrently file an I-765 and I-131 application, which are an EAD and AP. AP stands for Advanced Parole, EAD stands for Employment Authorization Document. Basically, it allows you to work while a green card is pending, and it allows you to travel while a green card is pending. Everybody should do that. I don't know why someone would ever consider not filing those, because it's free to file. There's no filing fee with the US government to file them with a green card application. And even if you have a stable work authorization status like H-1B that has dual intent, which would allow you to travel freely while the green card is pending, you should still file your EAD AP application, because it's a backup in case something goes wrong with your H-1B. Or like we saw with the backlog at the consulates for visa processing in the last couple of years in India, it would allow you to travel instead of needing to get an H-1B visa. So there's really, like, I don't know why someone wouldn't file an employment authorization document application, advanced parole document application with their green card application, just because there's no cost. Most attorneys do it for free as part of their I-485 application. If you're processing your petition on your own, like, there's nothing to lose. There's really no reason not to. And then you're just waiting for the approval. And I guess I should talk about processing times, right? The Administrative Procedure Act tells USCIS that they're supposed to review things in a timely manner for people. The EAD and AP were created so that somebody could have work authorization and travel authorization during the time their green card is pending. They're going to get sued a lot over this, and they already are being sued a lot over processing times for EAD APs, because right now they're taking around 8 months to longer for some people. And really, it's the type of application that should be processed in less than a month or so. So I would expect that date to speed up sometime in the next year or two. But we are hearing from government agencies that it's going to be a while before it speeds up because they're prioritizing other things.
Okay, now Brian, there's someone has just DM me a question actually. Well, for example, if somebody were to get, he is getting his likely to get or EB1A application in next 15-20 days.
Oh,
but
awesome.
Suppose if somebody were to lose a job in that circumstances, or his status would become invalid in 2 days. So what are the options for him? Can he apply for EAD or can he try for O1 visa to continue his stay? And what are the challenges that he would face to continue staying here in the US? And what would be your suggestion to such cases?
This depends. Your best option depends on so many factors. So like I would evaluate personally every case independently. It really depends on your opportunities and your marital status and and your spouse's status and a lot of other things. So I guess I'll go through the different options. If your spouse has H-1B and an approved I-140, you could immediately file for an H-4 and become a dependent of your spouse, which wouldn't necessarily be a problem. If you have an EB1A approval, you're going to qualify for O1. So as long as you can get another job offer or you decide to start your own business that has the ability to hire and fire you, you could file for an O1, or you could use an agent to file an O1. You could depart the country, which a lot of people, the reason we're talking about options is you don't really want to do that. You could file for an emergency EAD application. I haven't dabbled with those too much, but I know it's kind of becoming an option for people going through the layoffs. And it sounds like those are processing really quickly. You could also file if things got really desperate, you could file a B1 application just to patch up that gap while you continue to seek for employment other places. But I guess the takeaway is, if you lose a job, if you're struggling, if you don't really know what the next option is, there is an option for you to remain in the United States. There is something out there that's going to allow you to stay in the US. The problem is it might not be a work authorization option for the time being until you can secure employment somewhere else and extend your H-1B or go back to school or get an O1 or whatever else you need to do.
So could you tell, you mentioned about emergency EAD. Now, what's that actually? And how does that work?
That's recent. So they just developed the emergency EAD program, and I'm not super familiar with it, but I know that, like, just because I haven't done one yet. So I know generally about it. I read about it. I'm not an expert on it. So that's me saying, like, wrong person to go to for advice about it at this time. But I do know that if you've gone through the layoffs, that you can file for an emergency EAD and get work authorization that way if you're not finding employment somewhere else. But my whole thought with the thing is, like, most people are able to find a job in 60 days has been my experience, at least my clients that have gone through this. There's a few exceptions and they filed for O1s. So is an option. You can do it. It's just, I don't know. Personally, like, I like the other options a little bit more. So I usually try to get my clients through that.
Absolutely. So for emergent, because I think many of us are hearing it for the first time. So if somebody were to get his or her EB1 application and would like to apply, do you think there are chances there for emergent EAD?
Yeah, if you've gone through a layoff, you can file for an emergency EAD.
Okay, and does it have any validity period, or is it
I don't know how long they're valid for, so I haven't dabbled with it too much.
Okay, I got it. Now let me just, before I ask questions, let me ask someone. Gaurav, would you like to? You were the first one to raise your hand. Would you like to ask a question?
Yeah. Thank you. So Mike, I have 3 questions basically. First is, because they have indicated there are also a lot of backlog, means a lot of applications coming in. Do you think that will affect the approval of 140s for Indians in future? That's the first question. And let me put the other 2 also so you can answer together. The other question is, someone on L1A, they have specific time period, and after that they have to leave US. So for example, if someone has 2 years left, and if the 140 is approved, and the date is not current before their L1A is expiring, and they have to leave US. So what is the situation in that case? There's the second, and a connecting question to that is it possible to get EAD and AP before applying for 485?
I'll take the first one, the last one first. You can't get your EAD AP based on a green card filing without a green card pending. So the I-485 has to be filed for you to make those applications. You can file for them at the same time, but you cannot file an EAD AP application based on a green card application without the green card application being filed. Second question was L1A. So my first thought with an L1A is like, your employer should be filing an EB1C. Like, I don't know why they'd make you go down the EB1A path unless they're not willing to sponsor it, which hopefully they just are. If they were willing to file an L1 for you, I would assume that they're willing to file an EB1C application for you.
That's not an option. That's why EB1A is the only option left.
I don't know why an employer wouldn't do that. So like as an attorney, I would talk to your employer. Or hopefully your counsel's like, what are you doing to your people?
We have done that.
Yeah, that's a nightmare. Sorry about that. Most employers won't do that. And I'm not saying that's a bad, like they probably had a bad experience with immigration in the past, probably really good people. It's just, if you're willing to pay for someone to come over on L1, usually you're willing to cough up the fees for EB1C because it's such a high acceptance rate. But if you're trying to do your EB1A and you're looking for options to extend, you're probably looking at either an O1 or you're looking at trying to get your H1B through the H1B cap, which they should have been filing for you every year you're on L anyways. So H1B, O1, you could do same day CPT through a university program, going back and getting a master's degree or getting a PhD, or you could try out, well, the emergency EADs, it's not really an emergency because you're just coming to the end of your time, right? Like you're
L1. But if L1A is expiring and you are supposed to leave the country, would it not void your 140 as well? And then you
nothing happens to your I-140. Once you have an I-140 approval, you have it for life, unless it was withdrawn with. So like the one exception to that, if you have an employer sponsor an I-140 and they withdraw the I-140 before 180 days after its approval, then the I-140 is gone. If after 180 days you have that I-140, you have that priority date for the rest of your life. So you could essentially,
even if you leave US,
like let's say, here's an interesting thing. Let's say you got an I-140 20 years ago with an employer in EB2, then you left the country for 20 years. 20 years later, that employer could sponsor you for a green card based on that I-140, as long as it wasn't withdrawn.
In case of EB1A, where sponsor is not involved, would that be the case?
Yeah, you don't lose it. If you have an EB1A approval in I-140 and you leave the country, the United States has offered you full-time employment in the United States permanently. They've offered that to you, and that's valid for your life. So,
and you can apply for 485 even from outside US then?
Yeah.
Okay.
It's a little bit longer process usually, but yeah, absolutely.
Yeah. So, Brian, the same situation, does it also happen for EB1C? If
EB1C is sponsored by an employer, so as long as the employer is willing to sponsor your green card application when your priority date becomes current, then yes. But if the employer isn't willing to sponsor, then you kind of lose that benefit, right?
So, like in EB2, it can be ported from one employer to another, but EB1C does not mean porting, because today, if I've got EB1C approval, it is based on today's circumstances because I may have worked 1 year abroad in the preceding 3 years.
So it doesn't have the same portability. It doesn't have the same portability but that employer that filed the EB1C could do it.
Absolutely. So the same rules, it will be like a fresh application then in that case. Because if the employer has changed, then it would definitely imply.
Oh, right. Yeah, if the employer had changed, you would need a new sponsorship. You need to do something else. So at that point, you're probably doing either EB1A or hoping that you have a priority date from like 10 years ago so you can file an EB2 NIW or something.
Absolutely. So I get your point. Kinshuk.
Yeah, Brian, so I just need one clarification around the EAD part. I know you mentioned it earlier. So if somebody files an I-485 and an I-765 and advance parole together, but their priority date is not current, could it be possible that their I-765 or EAD application is approved while they're still waiting for the priority date to be current?
Super glad you asked this because I should have just said it. Yes. This is a super good question. So like if the situation is your priority date became current, you filed a green card application, it's in the hopper, it's pending, you filed your I-765 and I-131, they won't approve your green card if it backlogs, right? So the green card is going to continue pending. Because you have a green card application pending, you're eligible for an I-765 and an I-131. They will process that application and they will grant you your EAD and your AP, regardless of the backlog.
Got it. That's exactly what I wanted to know. Thank you so much.
Yeah, no, that's if you've got your green card pending, that's great news for you. So, because that means you at least have that security. And I would stay on top of that. One of the issues I see people having in that situation is once it's about to expire, they'll forget to renew it. So just make sure you do have to renew it every time it expires. And they've been issuing them recently so that they have longer expiration dates because they're terrible at processing things right now. But do make note of those dates on those documents, because the worst thing you could do is let something expire without renewing it. When you're in that period of time, you can renew.
Got it. Thank you.
Sorry, just to interrupt, one question from my side on this. What do you mean by green card application? Are you saying 485 application?
Yeah, the 485. Yeah,
okay.
I call it three things. So I call it the I-485 green card application or the adjustment of status application. All three of those things mean the same thing. I'm doing exactly what the Department of State does in sending out different terms here that they really should just have one word for all of it, right?
Yeah, thank you.
Yep.
Wonderful. Tejas.
Hi, I just wanted some more clarification on the first answer from Brian. So if somebody has an EB1A I-140 approved, what all flexibilities or what all privileges does that person have? Like even though they are waiting for like 10 years for their priority date to become current, like they can enter and leave the country, they can change the employer until what end?
So if I understand the question right, it's you have an I-140 approved. What's the benefit?
Yeah, in other terms, yes.
The answer is, for folks subject to a backlog, the only, in my opinion, the only benefit this is giving you is the ability to extend your H-1B beyond 6 years, which is a big benefit because in 6 years, you're gonna, well, unless we have like a 15% acceptance rate in the H-1B cap again, but within 6 years, I would expect every single person on this call to get an H-1B. Or within 3 years, usually people are able to get on H-1B, and it really allows you the flexibility to extend beyond that time. I would imagine if we continue to see issues like we are, that Congress will do something. I should be knocking on wood because they don't do much. But if they do something with immigration, like a lot of people are talking, they will. If we saw a lot of issues with people having to depart the country because they're not able to secure work authorization, I think that they would either increase the number of people in the H-1B cap or increase the number of visas for Indian nationals. There's been a lot of bills actually introduced to fix some of these issues in the last couple of years. It's just they can't drum up enough partisan support to get them made into laws. So hopefully we see some kind of positive change in the next 5 or 6 years, but maybe I should run for office and just see if I can fix things that way. But
right,
absolutely.
So essentially, then I can like change for jobs and apply for renewed H-1B. I won't like lose my I-140.
No, okay. So this is the other thing to consider. So like if your I-140 is sponsored by your employer, you won't lose your priority date from your I-140, but your new employer will need to sponsor a new I-140 petition in order for you to get a green card based on I-140, or your old employer will have to sponsor your green card, which that's super rare. I've seen it happen once in my career because you've left your employer, like you don't want to work for them, right? So they're going to have to go through the perm labor certification process again, or file an EB-1B or file an EB-1C or an EB-1A for you, or you can self-petition. But yeah, if it's an employment-sponsored I-140 and you change employers, you keep your priority date, you maintain the ability to extend your H-1B beyond 6 years, but you will need a new employer-sponsored I-140 to get a green card. Good news, the backlog's 20 years or so, 10 to 20 years, so you probably have time, which is actually terrible news, but it does mean that your new employers will probably have time to do that if you have recent priority dates. If you have older ones than that, you understand the process as well as most attorneys by this point.
Right. Absolutely. Brian, before we move to the next question, there is an interesting question that has popped up actually. And I think this everybody would like to ask also, that what are the chances of country quota of 7% not being there in the future? How do you see that? There has been a lot of speculation in the Congress or otherwise that, so where do you think this argument would go?
It's hard. It's hard to know what they're going to do, because it is the people most affected by this are Indian nationals, without a doubt. Chinese nationals to some degree. Indian nationals are suffering from the per country quotas. Otherwise, a lot of people view it as fair in Congress, but like to everyone on this call, it does not feel fair. There's so much momentum and so many people talking about this. I would be surprised if something doesn't happen in the next 5 years. I don't know what they would do. Personally, I wonder if they would increase the number of employment-based visas, because I think a lot of people are happy with the per country quotas. I don't know what they're going to do. There's so many proposals on the table. I've also seen a lot of people, there's been a bill introduced for Indian nationals with children who are aging out to be eligible to file a green card application so that their children can have authorization. I love that idea. Like whoever put that on the table, that should have been on the table a long time ago, because it makes 0 sense for someone to come to this country, wait for a green card for 10 years, just to have their child not be able to get a green card because they miss it by a week or two. Completely silly process. So that could remove some of the backlog as well if something like that passed, because a lot of people have been waiting for a long time would all of a sudden be eligible for a green card. So there might be something that gets passed in the next couple of years, but it's hard to know what it's going to be. There's a lot of people advocating for that. I'm part of AILA, and I've seen some stuff through AILA, but they're more worried about a lot of the family-based processes. So their attention gets kind of pulled into asylum and things, but there has been some momentum for the specifically for Indian-born nationals going through the things that everyone on this call is going through. Well, most people on this call are going through. There sounds like there's a couple people made from Nepal and other places, which you'll be able to find different options, which is really good.
Absolutely. The same person is asking another question, that is there a possibility and what is the process if EB-1A is for extraordinary ability persons? Why there is a quota? There should not be a quota for EB-1A at least.
Yeah. So, yeah, you should write your senators. My advice, every person on this call can write their senator and have their employers write their senator and have their coworkers write their senator. Everybody on this call should be writing a congressman member complaining about this.
So EB1A could be out of the quota. I mean, that's another very innovative.
Why not? I mean, seriously, there's going to, by the end of this, half the world's going to be extraordinary ability Indian nationals because people just have to jump through so many hoops to get a green card that, like, I mean, people that would have never thought about writing a paper in their life have thousands of citations now because they had to jump through EB1 hoops, right? So, like, yeah, it's crazy. So my advice would be write your senator and write your congressperson. I write them every year and tell them I'm ticked at the system. I'm in Nebraska, so they kind of laugh at me. But yeah, I would.
This overpopulation of EB1s and that retrogression, is it happening because of EB1A or EB1Cs actually?
I think it's a combination of the two. There's a ton of people that have done the jump to Canada, work for a year, and then file an EB1C application.
Absolutely. Because statistics, I think, show that EB1C has gone up more than EB1A actually. So all are in the same category. It's EB1, so that's causing a lot of anxiety because of
and it's a super easy petition. Like, it's very, like, in my opinion, it's so much easier to get an EB1C approved than an EB1A. So it's yeah, if that's an option, if your employer will let you work from Canada for a year, from India for a year, and you have that option, totally worth it. Which obviously you don't want to uproot your family and move for a year. Like, that's a complete nightmare, right? Like, I'm saying this as an attorney sitting in my basement that will never have to travel and move my home. Like, that's completely crazy to me, but it's an option and a lot of people have done it.
Absolutely. So Arvind, you are next on the question.
Yeah, hi. My question is more about the fingerprinting part of it. Now, if somebody has filed a 485, 131, and 765, will I have two set of fingerprinting done by USICs for me, or it'll be like one for that goes for 485 and the same goes?
Pull you in again for your biometrics. So when you file your I-485, regardless of what they have on file, they're going to they will most likely, and they don't always, but almost always, you're going to get pulled in for you'll get an ASC appointment notice and have to go in for biometrics. But good news is I have heard recently, most of my clients are doing this. They get their appointment notice and they're just doing walk-in appointments. You can go before your date they schedule.
Okay,
but they're going to pull you in for fingerprinting.
Yeah, no, since I filed like two applications, one is 485 and other is the EAD and the AP.
Oh yeah,
both of them
pull you in once for both applications.
Okay. Since I've heard other cases as well saying that it'll be like two sets of fingerprint, that's why I asked the question.
I have not seen that. All the I-485s I filed have got one notice that lists both processes.
Okay.
But I guess that would be, if they did that, I would have your attorney or I would myself call USCIS and complain about that. Like, they should not need to have you do that. That's ridiculous.
Okay. Last part is not a question, more of an observation. Now, since this retrogression has happened, we see the date of filing has gone. Sorry, date of filing still remains like in 2022, but the final action date has gone back 10 years. Had the retrogression needs to stay here for a longer time, then the USCIS would have moved both those dates back. Now, since that's a good indicator for us to be positive about that, since the date of filing is still in 2022, they're gonna put it back soon, faster.
Yeah. In October, it's gonna jump back to 2022.
When you say October, that means in September month when we get the October bulletin.
Yep. I would be I could be wrong. Like, there's a chance there's a little bit of retrogression there, but I would be 90% sure we'll be looking at a 2022 priority date in October. There is a chance that's a 2021 date. I think it's going to be 2022. I actually think personally it's going to move forward a little bit. I don't think it'll be February. It could still be February. I think it's kind of a 50-50 chance of it staying February or moving up to March or April or something. But I think we'll probably see February 2022 or March 2022 or something in October.
Absolutely. So, yeah, any question? Yes, Arvind?
The last part was that since Brian mentioned that we can even go for a walk-in for a fingerprint before the date of appointment. So does that help to expedite the, let's say, EAD application if the green card is not current? Does it help going for a earlier appointment date like a walk-in and accept it?
I don't think so. But
okay.
It just means you have a little more flexibility. Like if some people worry about missing their appointment for some reason, like let's say the day of your appointment, you get sick or something. People just like to be sure it's finished. So every one of my clients, I've told them they have that option. They've all done it because most people just want to get it over with. So I don't think it really does anything for your application though, personally.
And after
Okay,
getting
Arvind, I think we'll ask other people. There are a lot of guys, so just hang on for some time. So Sina, would you like to ask a question?
Yeah, sure. Thank you. Brian, I had a question about like being on a program while also applying for EB-1A. So say someone who's on their master's OPT right now and have a valid visa for a few more years, applies for their EB-1A, and the EB-1A is currently in either an approved state or it's pending with RFE, but would be, maybe it's at a stage where it would be approved in a short while. And while this is happening, they end up going back to a PhD program and start their program. So, and they don't leave the country during this process. So eventually, if they do graduate with a PhD, what happens is once they have given their prelims, they can apply for an OPT, and that would be an OPT based on their PhD. So because the priority date is not current on an approved EB-1A, would that hamper the process of getting an OPT if they have? Yeah.
This is great. So F1 in the field adjudicators manual for F1, it talks about this. It says that when they process your F1 visa or an OPT EAD based on your F1, they shouldn't consider approved I-140s as an expression of permanent intent for purposes of processing those visas. So, because again, remember earlier when I was talking about the I-140, how it's like, it's kind of like a job offer. That's how the US government's supposed to think of it as well. They're not supposed to think of it as you expressing your intent to remain permanently in the US. They're supposed to view it as you having the option to express your intent. Because just because someone has an employer-sponsored I-140 doesn't mean they want to file a green card.
Yeah, this is really great to know, actually. Yeah. And I had a follow-up question with regard to this. If somebody who is on their F1 OPT, master's F1 OPT, decided to pursue their PhD while also working, and say both the school as well as the employer are in agreement. So at some point during their program, they'll have to transition from their F1 to their H1B if they would like to continue their work at their current organization. So do you think there is a chance that their H1B would be denied?
No.
Okay.
And you could stay on H1B and do if you were working still, you could do school and be on H1B, or you could be on F1 CPT, F1 OPT, F1 STEM OPT and have a job and go to school at the same time.
But would that be like a full-time job, or would that be more of a part-time job? Because I know there are restrictions about the amount. Oh, okay. Okay.
Yeah, just be careful with all the CPT, OPT things, because the regulations are kind of processes them a little differently. So you just need to like talk to your DSO at your school to make sure that you have the correct information from your university. Because I actually had someone recently that their school didn't explain things very well to them, and it's really impacting them. So definitely like be in communication with your DSO as well as your attorney and everyone else. But yeah, there should be no issues with the H1B and things because you're in school.
Okay. Thank you.
Great. Kaushik.
So Brian, I have a different question. So this is one of that EB1C. I know, I mean, you just mentioned briefly. So if you are on H1B here for 3 years and it's just 1 year and your company can send you to Canada on, I don't know what visa, but can you then come back after a year on the same H1B?
Yeah.
Or you can, right? It doesn't have to be L1 or other stuff. You can come on H1.
So there is a little bit of like, there are rules in place here. but yeah, as long as you have time remaining, as long as you still have time remaining on your H-1B or you have an approved I-140, you can extend that H-1B and come back on it later. So you could depart the US for a year. This is actually, I like this strategy. So because it preserves your H, and like H-1B, I know there's a lot of negativity out there about H-1B. For purposes of processing a green card, it's like the best visa to be on because of the intent rules. And I know there's some limitations with like starting your own job and or own company and things that entrepreneurs don't like about it as much. But as far as like getting your green card, H-1B is great. So like scenario, you depart the US for a year, you get eligible for EB-1C, you come back on your H-1B, you can do that. And you also are eligible for an EB-1C. That's great. Like that's a good option. But I really, it sucks that people have to uproot to do that. But I know that it's an option. It's something you can do. And a lot of people are doing it. And mostly to Canada, because Canada is so easy to get employment authorization. And they love extraordinary people. Americans do too. Our laws just are stupid. So
that makes sense. Yeah, thank you.
Yes, Ram, you have a question?
Yes. Hey, thank you for organizing this. But I had a quick question again on EB-1C. I came to know that so not only people managers, but also the concept of functional managers, if you're a tech lead or if you're generally overseeing a function, but not in a people management capacity, but in an individual capacity, you can also apply for EB-1C. Based on what you've observed, have you generally seen significant, like RFEs or success rate drops for EB-1C based on the functional manager role?
More than EB-1C that are like a more traditional manager, but yeah, the functional managers, I don't see too many issues with. Especially the issues for most functional managers happen at the L1B stage. And that's where they pick up their RFEs or their denials more often. There's really high levels of scrutiny in the L1B range, but a lot of law firms are actually really good at processing the EB-1Cs and the L1Bs. So like I used to work for a huge law firm in New York, and I worked on a team that filed hundreds every month, hundreds L1A, L1B, L1 whatever, L1A, L1B, and then EB-1C applications. Hardly ever saw pushback. So as long as like the attorneys have a good process and it's a legit role and you're actually managing a function and it's like really clear that you're doing that, should be fine.
Okay, thank you.
Thanks. Now there's another question here, Brian, that can somebody's, just a second, let me just pull up that question. There are too many questions here. But if somebody's spouse from India has EB2, can it be ported to EB1A actually for the priority date purposes?
I think I understand. So the question is like person A wants to file an EB1A application. They're married to person B who has an EB2 priority date. Can they use person B's priority date in person A? What?
Yeah, just I think, yeah, no, sorry. I think
the answer is no. Like you can't use your spouse's priority date for your application, but they could use it to do an EB1A. And then they could sponsor you for a dependent-based green card application, which will count against the backlog. So that's another thing that people that pushes the backlog, right? Every time someone has like 3 or 4 dependents, that counts towards the visa backlog as well. But that we want people to get their spouses a green card too. So
absolutely, but this works in inter-country, am I right?
Right.
Inter-country this works, but same country it does not work.
Right.
Okay. Now there is another question here. Now same spouse cannot be done. What about EBW? And I think there are, you may like to look at the questions given in the chat.
Yeah, I think I caught one of them earlier. I can look real quick.
Now, these are very generic questions. If I have a book published in Nepal, am I eligible for EB1A? I think this is not the forum where we can answer this question, but answer straightforward, it's very difficult to respond actually. Just on one book, one country, eligibility cannot be established. There are a lot of parameters that go into it.
Yeah, and sometimes books don't even work, right? So it
Yeah.
really depends on, there's a lot of things that go into that.
Absolutely. So we are just trying to be responsive to as many questions as possible. And some of you have DM'd me, some of you are DMing Brian also. How much weightage for PhD degree from India for EB1A? I mean, I always mention actually in the program also that EB1A is not about your degrees or qualifications. It's about your expertise. So degree won't matter actually per se. And I think someone has responded. Arvind has responded.
Yeah, Arvind's right on, right? PhD helps because you've been able to publish in things, but there's plenty of master's applicants who get EB1A.
Absolutely. Now, if an EB1B application is filed by an employer under normal processing, can an outside attorney, what do you mean by employer has done it? Can an outside attorney file a supplemental application to change it to priority processing? I'm not able to. Do you get this question?
I don't know why you would have an attorney file that premium processing application. You can just do it on your own.
Absolutely.
The I-907 is super, super easy to fill out, and USCIS doesn't care. It's the only form USCIS does not care about mistakes on because they want your $2,500. So,
yeah. So there is another question. Can you highlight options available for someone at the end of 1 year of H-1B and waiting for I-140 approval?
Oh, that's so hard.
I think you took this question, I guess.
What I would suggest is you can either apply for an emergency EAD. What I tell people, you want to preserve your H. You want to preserve your H-1B. Like you're at the end of your 6 years, preserve your H-1B. I had a guy in this exact situation like 3 years ago. A week before his H-1B expired, before he hit his 6-year visa max, I had him fly home to India, where he waited until his EB2 was approved, and then he filed for an H-1B consular process, got his H-1B visa abroad, and came back into the country. And that was the right option for him. Like it meant he had to work remotely for a while from India, but like it means that he can extend his H-1B beyond 6 years. So it was totally worth preserving that H. So I would suggest preserving your H-1B. If you absolutely have to, there's options to do that. If you have a spouse on H-1B, you can switch to H-4 EAD, especially a good option if they're extending their H-1B anyways, because USCIS is now processing H-4 and EAD applications filed at the same time as an H-1B extension concurrently. So they will, if your spouse is paying for premium processing on an H-1B and your H-4 EAD application is attached to it, they will process that within 15 days. That is a super good option for someone at the end of their H-1B status if they're married and they have a spouse on H. So that's a good option. You could switch to B, you could switch to O. There's a lot of things you could switch to. If you got an EB1B, you definitely qualify for an O1. But yeah, definitely preserve that H. That was a really long answer. Sorry about that. Success rate of EB1A applications. What do you know, Ranjeet? I think it's like 90, not 90. I think it's like 83 something %.
Yeah, it changes every quarter actually. So
yeah,
so we get that. So it has been hovering from 60 to 80, 85, I think so.
Yeah, I think it's lower now than it has been historically. They got really tough on it back in December. It seemed like we were getting some more pushback December through like March. Things seem to be getting easier. It really depends on your application, but they've been really tough on salary recently. Success rates are so hard to predict, but somewhere in that like 65 to 80 something % range.
Absolutely.
Which is high, but also the quality of candidates is really good.
Okay, so there are 3 hands right now. So 2 of you have already asked. So I'm going to ask Nish to ask the question.
Hey, Brian. My question is that I am right now on L1A and my employer has filed for EB1C application, and I have just filed right now for premium processing, which takes $2,500. So my question is, like, if I receive my approval within the next 45 days, and if my employment gets terminated, what are the options I have?
Oh, yeah. So you're on L1A. you have a pending EB1C, you're paying premium processing for that application. You'll get a decision. If your employer, even if you pay premium processing, if your employer withdraws that I-140 within the next 180 days, it's gone. Most employers will not do that. Like, it's really bad practice. It's bad employment practice, and they get bad reviews. So like, I've only heard of one company ever that has a process in place to withdraw I-140s, and they're probably going to go under because they're just vindictive. I would be really shocked if they did. So you'll still have the priority date from the EB1, but you're going to have to search for a different non-immigrant visa option. So you'll probably want to look into the H-1B cap, going back and getting a PhD or master's, doing same-day CPT, getting an O1 visa, or getting on a dependent non-immigrant visa or something like that.
So Brian, in this particular case, we discussed this earlier that in case of EB1C, if the employer were to change, again, they will have to refile the whole application, but the conditions for the EB1C may not be fulfilled during the next application because...
Right, yeah, no, you're going to have to get a different type of I-140.
Exactly, that is what my point. Unlike EB2, where the circumstances, the EB2 is given based on your master's degree, essentially, and a PERM certification. In case of EB1B, let's say a person is with employer A, get it approved, but unfortunately loses the job, and employer B, even if it is not withdrawn, does it, but employer B can approve it only if the conditions for EB1C are fulfilled, like 3 years prior working in the different country for 1 year. But the only thing what can happen is, again, he may have to, for the employer B, he may have to serve in a different country for 1 year. And he may port the priority date. Am I right? Is this understanding correct, Brian?
Yeah, that's right. Yeah, no, you're just gonna have to find a different option for your EB1.
Absolutely. So EB1C is
unless the employer, even though they let you go, let's say 6 months from now, they're hiring again and they're willing to take you back, they could sponsor your green card application still.
Absolutely. That's a very good possibility, very optimistic possibility, I would say that.
Not very common. I've only seen it happen once again.
Yeah. But what I like about you, Brian, I must tell you that you are very innovative, actually. I mean, I think that's what is very wonderful, and you give very constructive solutions rather than just being a bureaucratic legal, possibilities, actually. So that's, thanks a lot for that, actually.
Yeah.
So wonderful. So Arvind?
Yeah, Ranjeet. I think my question is a follow-up of where I ended last time. If I filed for a 485 and I have 485 and 765, 131, and my fingerprinting is done, so is it okay for me to leave US and come back on an H1B, let's say in a month's time? Does that cancels my AP? That's what the myth I've heard only.
Yeah, it will. Yeah, so this is a good question. I think before this, we were talking about, Ranjeet and I were talking a little bit before our meeting about a USCIS officer who once said, like, you can try your luck. That's how traveling while an I-131 pending is. It's kind of like, if you depart the country, technically they're legally supposed to deny your I-131 application, which has no impact on you whatsoever. There's nothing wrong with having an I-131 denial. But what happens is when you come back into the country, say on H-1B visa, which if you're going to do this strategy, please have an H-1B visa, or please have an H-1B at least. You'll just have to refile your I-131 once you re-enter the United States.
But even if I enter on a H-1B, that still impacts my AP application, right?
Yeah. But honestly, like, it's an AP application. You can just refile it. But that strategy, like, you really want to be on H-1B if you're going to travel. I wouldn't do this strategy on any other status. H-1B, possibly L1, but because H-1B is and L1 have non-immigrant and immigrant intent, which allows you to travel because while the green card application is pending. But I would consult with somebody before traveling with an application pending.
Sure. Thank you, Baba. Though I could always ask that even if my AP gets cancelled and I come back and refile it, so that being basically I'm adding a bit more time to my AP approval. Then otherwise it might have come earlier.
It'll just move back in the queue. Right.
Right. So, yeah. Got it. Fine. Thank you. Thank you.
So Brian, before we close out the session, the last question that is, I think, in everybody's minds that you spoke about this retrogression happening in 2016, 17, 18. At times it has been current also, again, bounced back as current. So what's your speculation for priority date for EB1A to become current actually?
I don't know. This is, who knows? Like the talking heads, every attorney, every one of us could speculate. And there's some attorneys that are actually pretty good, but it's kind of like talking to the weatherman. Like we'll make a guess, but like it's probably going to rain even though we say it's going to be sunny. It will become current again, I think. I think it's going to be a couple of years at least. They're going to have to do something to clear out the backlog, or enough people are going to have to depart the US or use this option for the backlog to clear out. I think it's going to be, I think we're in for a backlog for a couple of years at least. And my guess would be 2, I don't know, maybe less, maybe more, but I think it will clear out eventually, just because the people seeking EB1A are mostly people who have been here for a while, who are fed up with the system, who have established EB2 priority dates. What that's going to do, the long-term impact, and it might be a long-term impact, it might be 20 years or so, that'll clear out the EB2 queue as well a little bit. That'll clear out the EB3 queue out a little bit. So those might become more viable options in the future again. So like, I think we're going to see a number of things happen, but I think the backlog is around for a little while at least. I think we'll see it for a couple of years. But again, I don't think it's going to be more than a year or two, which is why I think what we talked about earlier of continuing to pursue this as an option for a green card is a good option, because it's probably your only option if you're Indian born and you want a green card in the next 5 years instead of the next 20 or 10.
Absolutely. I think that's a wonderful take, because EB1A is still the best option, and the journey of it, the pursuance of it actually takes the best out of you actually in the whole process. That's what I like to put it. It's transformational. It helps you to do it. Yes, if you have any other option, we should definitely exploit it. But this, I think, whatever has happened this August 2023 bulletin, this should not deter us. That's the only thing. If you are on your EB1A path, pursue it actually. So that's the take from all this today's discussion, guys. And thank you very much for a very active participation. And Brian, as always, it has been wonderful to have you, known you. And thank you very much for all the support.
Yeah. Thanks, Ranjeet. It's good talking to everybody. And someone did say in the thing they wanted me to leave my information. I didn't. But if you want to get in contact, like I have a website. It's called Lisonbee Immigration Law.
Absolutely. And if you look at the post that is being mentioned for this particular, this session, the brand's website is also mentioned there. I mean, not website, the LinkedIn is there. You can just contact him anytime. You're always welcome.
Yeah.
Thank you very much, friends, and have a wonderful day. Bye.
Thanks, Ranjeet.
Thank you, Brian. Bye.
I'm going to leave too.
Okay, bye-bye.